And so many thanks to Doha and the competition policy and advocacy section for, I think, really assembling a wish list of top lawyers particularly in the fields of antitrust and collective bargaining. I'll go through the intros real quick. We have a 5:30 stop time, and I want to hear as much from them as possible. You can read their bios, but I'll go down the line, starting with Jonathan Berry, who's the Principal Deputy Assistant Secretary for Policy at the U.S. Department of Labor. Then going down the line, we have Derek Ludwin, who is a partner at Covington and Burling. Then next is Sanjukta Paul, who is a law professor at Wayne State University. And then I see Steve Cannon, who is the chairman of Constantine and Cannon and the managing partner of Constantine Cannon's Washington, D.C. office. And then next to Steve is Jeff Kessler. Jeff is the co-executive chairman and co-chair for the Antitrust Competition and Sports Law Practices at Winston and Strawn. And then finally, we have Matthew Ginsburg, who is Associate General Counsel for the AFL-CIO. So let's jump right in. So the focus of the panel is going to be on the labor exemption from the antitrust laws. And more generally, we're going to cover the past, the present, and the future of the intersection between these two areas of law, antitrust and collective bargaining. As we'll discuss, the statutory and non-statutory labor exemptions have a long history and have proven integral in protecting the rights of workers to organize and collectively bargain. When competitors come together and agree on the prices that they will charge to a purchaser of their inputs, antitrust lawyers usually see that as an antitrust problem, and they're agnostic to the underlying reasons for such horizontal agreements. It's unsurprising, then, that after the Sherman Act was passed, collective bargaining and unionization efforts were on a collision course with the antitrust laws. But, as you will hear, Congress passed a series of laws that are now known as the labor exemption from the antitrust laws. These statutes immunize labor organizations that are lawfully carrying out their legitimate objectives. The labor exemption, statutory exemption, enables workers to organize to eliminate competition amongst themselves and to pursue their legitimate labor interests, so long as they do not combine with a non-labor group. That's the words of the Supreme Court. The statutory labor exemption, however, does not address agreements made between unions and employers. So recognizing that this would subject collective bargaining agreements between unions and employers to antitrust scrutiny, the Supreme Court inferred a non-statutory exemption to accompany the explicit statutory carve-outs. The non-statutory labor exemption has two main underlying rationales. One, the need to provide for labor peace, and then two, the desire to allow labor policy rather than the antitrust laws to control the realm of collective bargaining. So at the same time, one thing that unites many antitrust lawyers, and we'll talk about this more, is an aversion to exemptions or immunities from antitrust scrutiny. In fact, in 2007, the Bipartisan Antitrust Modernization Commission, on which Steve Cannon sat, issued a report on the state of antitrust law with recommendations for future development. In its discussion of exemptions and immunities, the report states, statutory immunities from the antitrust laws should be disfavored. They should be granted rarely and only where, and for so long as, a clear case has been made that the question would subject the actors to antitrust liability and is necessary to satisfy a specific societal goal that trumps the benefit of a free market to consumers and the U.S. economy in general. So on the one hand, an aversion to antitrust immunity doctrines, even when there's an express statutory immunity, not to say anything about the non-statutory immunity. But on the other hand, we have the statutory federal policy to protect collective bargaining. So some of the questions today will explore this tension, but more broadly, we'll cover the purposes of the statutory and non-statutory labor exemptions and how the exemption is still being litigated today, and then we'll talk about what might be next in this area. To start, we're going to forgo opening statements, but I'm going to have a kickoff question to each of our panelists that'll help us sort of, look at some of the big picture issues in the space, and then we'll get into some of the more applied topics, digital, sports, and so on. So I'll start with Sanjukta. Could you start us off by providing some of the key background history underlying antitrust law's relationship to workers, including what we now call the labor exemption antitrust law?
Absolutely, thank you. I'm going to try to shake up our background assumptions about this topic a little bit, and actually I'm going to do that by talking about what I would call the prehistory of the labor exemption, something we don't talk about very much. Workers and workers' organizations, in particular the Knights of Labor, which was the AFL-CIO before there was an AFL-CIO in the 1880s, were at the core of the social movement that helped to get the Sherman Act passed in the first place. Thank you. Sorry. And together with farmers' organizations, historians agree that they were really at the core of this anti-monopoly movement. We know this as well because legislators repeatedly referred to this fact in the legislative record, which I spent a chunk of my summer reading from beginning to end. It's true. And needless to say, neither of these groups of people dreamed that coordination between themselves, whether it was in the form of joint bargaining or joint price setting as to their rates, would come within the ambit of the statute. Now, we've heard sort of the conventional framework for why we today think this is the case. So I'm going to try to unsettle our assumptions about that just a little bit. Let me start with first the facts. Quite simply, the legislative record shows that legislators did not intend for the Sherman Act to bring workers' coordination or coordination between farmers and small dealers within its grasp. It's not really a close question. I'm not the first person to say this. Back in the early 20th century, this was quite a hot topic, and early commentators made this point. We also know that it was not legislators' intent because they said so over and over on the record. And they discussed it because they were worried that the courts would interpret it this way, right? So they talked about how can we draft it to avoid this possibility, and that is exactly what the courts did. As I read the record, in fact, the final redrafting of what we now know as the Sherman Act was in fact done in large part in an attempt to avoid precisely this eventuality. It removed some language about raising costs, and they thought that took care of the problem by tracking the common law language of restraint of trade. As you all know, the restraint of trade doctrine at common law did not actually prohibit price fixing per se, and this was not an issue in the same way at common law. Now, to really understand this, though, we have to understand what legislators were trying to do, and it was quite simple, really. They were worried about the power of the trusts. That's why it's called antitrust law. The trusts were a new type of business form that had not existed until the 1880s. Trusts were like today's large corporations in all respects save one. There was an additional formal layer to their corporate governance in the form of these trust certificates that were issued to shareholders in individual constituent firms in exchange for voting power over their shares that was held by a small centralized group of trustees that, kind of like the board of directors today, that now controlled all the constituent firms as one. Trusts existed because state corporate law at the time made outright merger largely impossible. And the important thing to understand about trusts is that they were a mechanism to deal with what I would admit was sometimes destabilizing competition in the emerging national markets. Through a mechanism that was different from prior forms of market coordination because it concentrated power in much fewer hands than was previously the case when we had more regional and local markets. As Senator Sherman said, John D. Rockefeller might have been a fine man, but the danger was that he held more power over economic coordination than one man should. The somewhat challenging thing for us today to understand is that the people and legislators were focused on the trusts insofar as they were like today's large firms, not insofar as they were like coordination between firms or individuals, tiny firms, Uber drivers, whoever. And this is the precise opposite of the priorities that today's antitrust law sets, labor exemption or no labor exemption. But the act, while it perhaps could have been drafted more clearly, absolutely was aimed at the concentrated power of the trust, which really is represented by large corporations today. And again, the dispersed nature of worker and farmer coordination was not considered an antitrust problem. So what about those early cases that preceded the New Deal and preceded also the Clayton Act's labor proviso? So the courts did not see this the way that I see it, and they largely ignored legislative intent on both counts. I won't go through the whole development, but I want to highlight two Supreme Court cases. One is the one that all labor lawyers know as the Danbury Hatters case, Lowe v. Lawler, and this actually built on a couple of federal district court decisions, and in that case, the Supreme Court summarily dismissed legislative intent with, frankly, a rather misleading statement about attempts to pass a labor exemption having failed. That's not the case. The legislators rewrote the statute thinking that no labor exemption was now necessary, right? The other thing I want to highlight about Lowe v. Lawler and the other cases of that period that preceded the Clayton Act and preceded the New Deal is what their rationale was for breaking up labor strikes and boycotts. It was not that they were anti-competitive or akin to price fixing, and on the contrary, many of these cases actually said that collective bargaining over wages and working conditions would actually be fine, they either implied or said that itself would not be a problem, rather whether they held that employers had property or property-like rights that were threatened by many types of common strike activities. And furthermore, the federal courts read those specific employer rights into the federal antitrust law. At the same time, around this same time, we had a trio of cases on the merger side, EC Knight, Northern Securities, and finally Standard Oil. And I won't go through all of them, but in Standard Oil is really where we got the modern distinction between unilateral and multilateral conduct. That is not something that legislators contemplated. It did not exist in the law before. And prior to Standard Oil, for example, in Northern Securities, the court actually moved toward treating horizontal mergers akin to price fixing between competitors. And that is in line with the legislative intent that I'm highlighting, that was concerned with concentrated power and with the problem being concentrating coordination rights in too few hands. And again, this was a major step in the process that eventually made coordination between firms and individuals the, quote, supreme evil of antitrust, which it was not originally, rather than focusing on concentrated corporate power. Now, very briefly, I think that my colleague is going to talk about the statutory and non-statutory labor exemption, but what we now know as the labor exemption to antitrust was articulated, I would say, in a pair of Supreme Court cases in the early 1940s, Hutchison and Apex Hosiery. And these really knit together the labor proviso that can be found in Section 6 of the Clayton Act, which had been rendered more or less a dead letter by the Lochner-era federal courts, knit that together with the Norris-LaGuardia Act, which was of New Deal vintage, and to some extent also knit together judicial interpretations of the Sherman Act and the Wagner Act as well, which is the NLRA, the basis of the NLRA. These cases said that taking labor costs out of competition was not a violation of the Sherman Act. Indeed, it's important to note that these cases said that that's true as a matter of the Sherman Act, that is not what the Sherman Act implied, not just sort of what, as it was later modified by whatever the labor exemption is. And this is indeed, I would submit, consistent with a careful reading of the Lochner-era labor antitrust cases as well, insofar as those cases focused on the means by which workers sought to achieve union shops or to better their wages and working conditions, often involving secondary action or other activities that the courts considered to be interference with employers' property rights, as I mentioned. Rather than being concerned with the end of collective bargaining, which we just assume today is an antitrust violation. I just want to also briefly say that we wouldn't accept the reasoning that the Lochner-era courts used today that focused on the means, because I don't have time to go into it, but they really focused on the social status of workers and whether they were sort of fit to engage in the kind of coordination that business people were, which is quite alien, I think, to the way that we would think about this. However, we do use a rationale that we cannot find in these cases about collective bargaining itself constituting an antitrust violation. So I think I will leave it there.
All right, thanks, Sanjukta. I'll go over to John to give us a bit more table setting, specifically from the labor perspective. So how did the background employment law rules influence antitrust law considerations?
Oh, thanks, Bill. I'll start by making the conventional distinction between labor law and employment law. Labor law speaks to the process for collectively negotiating the employment relationship. The rest of the panel is going to talk about how labor law intersects with antitrust law. So I just want to flag one feature, which is namely that in a unionized workplace, the National Labor Relations Act requires unions and employers to bargain over certain core terms of the employment relationship, such as wages, hours, time off, benefits, and workplace safety. Employment law, by contrast, goes to the substance of those core terms and sets some substantive floors on those. So here's just a quick general overview for those who may not know. So with these topics, wages and hours, the Fair Labor Standards Act sets a minimum wage and requires overtime after 40 hours a week. I'm speaking in generalities. There are tons of exemptions, and lawyers make a lot of money off of those. Time off, another one, Family and Medical Leave Act guarantees up to 12 weeks unpaid leave for illness and for family care. Congress is, of course, currently considering whether to add some kind of paid leave benefit or mandate as well. Benefits. The Affordable Care Act requires many employers to offer subsidized health insurance. And ERISA, the Employee Retirement Income Security Act, puts a host of obligations on employers who offer retirement or health benefits. Safety. The Occupational Safety and Health Act puts a general duty on employers to protect employees from workplace hazards and to comply with a variety of safety standards on specific topics like chemical exposure, fall protection, and dangerous machines. So for workers who are covered, and that coverage issue is very important, I'll come back to it later. For workers who are covered, employment laws set a fairly comprehensive floor for how those workers will be treated. All else equal, again, big caveat, this floor reduces the relative desirability to workers of collective action. If the main concern at your workplace is safety, maybe the OSH Act does enough to reduce or address hazards that you don't think a union is worth the lift. Likewise with the FLSA, perhaps, if your main concern is overtime. So to the extent that antitrust law concerns itself with the question of workers' practical economic incentives, it should take into account, I think, how employment law speaks to at least some of those incentives. And that's all I wanted to say.
All right. Thanks, John. So I'll go over to Derek. And Sanjukta gave us a very useful and informative discussion of some of the background principles and the origin story of what we call the labor exemption today. So I guess fast forwarding to today, what do we understand as the purpose of the labor exemption? And do you have a different perspective from Sanjukta that you might add?
Sure, I'm not sure I have a different perspective. I think I have some additional modern day gloss that I will add. As you heard, labor law looks at the process of bargaining, and it protects the process of bargaining. And there are many cases that talk about how national labor policy favors free and private collective bargaining, and it does so between two sides, labor and management. And the purpose of the exemptions together is to protect that process. So taking them in turn, the purpose of what is known as the statutory exemption is pretty simple. It protects from antitrust scrutiny, quote, unilateral conduct, sort of flowing from Standard Oil, unilateral conduct by a union acting on behalf of its members. Congress did not want unions to be considered cartels, and tried, took more than one try, but eventually got enough legislation in to make that happen. And it didn't want, because unions are not cartels, it did not want federal courts enjoining them from doing all of the things that labor law says that they can do. Again, this is the unilateral union actions. And the Congress didn't put in an express exemption. What it did is it put in a prohibition on injunctions, but the, quote, statutory exemption, which flows from that prohibition on injunction, has as its basic purpose protecting 1/2, or really 1/3, of this bargaining process. The non-statutory labor exemption protects the other 2/3, the other 2 parts of this bargaining process. And really what it does, its purpose is to give practical content to the statutory exemption. Because it's all very well for the union to have an exemption to go out and unionize, and maybe to strike, and maybe to demand collectively terms and conditions of employment. But that doesn't really get anyone anything if the union then can't agree with management on a contract that gives effect to where they've landed on these terms and conditions. So the non-statutory labor exemption, it's implied to cover concerted conduct, and it does so in 2 respects. First, as I've said, it covers that the agreement, the concerted action between the union and management to give effect to the fruits of the bargaining process. But the other thing it does is it recognizes that management isn't always unilateral on its side. The law favors, national labor policy favors, multi-employer bargaining units. And if you are going to have a group of employers working together on the other side of a union working together, with its members, you can't give effect if the agreement among those employers about how to respond to a demand by a union for an industry-wide term or condition, if that's going to be subject to antitrust scrutiny. So, the purpose of the statutory and the non-statutory exemptions working together are to protect this broader sort of soup to nuts collective bargaining process and the agreements that arise as part of that process. But an important part of that is to preserve the balance that Congress intended in this process. Labor law, and John can speak in much more detail than I can about it, but labor law and the collective bargaining process, is predicated on this balance between things that unions can do, strikes, and things that management can do, lockouts. And what these exemptions acting together do is protect both and maintain that balance that exists and is supposed to exist in the collective bargaining process.
Thanks, Derek. So I'll turn to Steve next. So we've heard a lot about what the labor exemptions protect, the activities, both at the collective bargaining stage in terms of union organizing activity. So what doesn't it protect? What are some of the outer boundaries of the labor exemption as we understand it today?
Well, it is interesting that it took, 40 years from 1890, from the Sherman Act, to at least 1932, to Norris LaGuardia, to clarify what I'm convinced now is clear. You've convinced me of that. But which actually is pretty speedy for the Congress, I guess. 42 years is not that slow. But I mean, the whole idea of what the exemption covers, both the statutory and non-statutory, it has somewhat of a parallel like in the state action doctrine, which the antitrust folks in the room know is this question of conduct of state entities, et cetera, not being subject to antitrust liability because it's the act of the state as sovereign and not, and so therefore anti-competitive activities you cannot reach a state on. That actually is, as folks know, is actually court-made law. It's not statute-made law, which makes it even more complicated. But here, there has been a pretty good rollout, if you will, of cases over the last 20, 30, 40, 60 years about what it really does mean. And when you get back to Hutchinson, which really started this entire thing about, you've got to make sure that the union is acting in its self-interest, and it is not acting with, this is the double negative, it's not acting with a non-labor organization, if you can follow those double negatives. And that's what the courts have tried to flesh out. There's so many of these cases around that it's pretty easy to have any number of examples. One of all things, back 30, 40 years ago, involving the international longshoremen, you would not be surprised to hear that if the union decided in protest not to unload ships because of the Soviet invasion of Afghanistan, that's not covered. What a shock. However, there's another case involving the National Basketball Players Association, where decertification of a agency for players was found to actually be in their self-interest because it could have an impact on terms and conditions of employment that the players would have. There are all sorts of other cases. Another landmark case I haven't talked about is H.A. Artist versus Actors Equity. Supreme Court decided in 1981 that essentially reaffirmed what everybody calls now the economic interrelationship test, and held that agents that represented equity members who had agreed to abide by the terms and conditions for franchising those agents, in fact, did qualify as a labor group. So when you start parsing through these cases over the years, sometimes you can just tell people, knowing what the broad principles are, there's a little bit of guessing going on whether or not the particular activity that you are wanting to do would cover it. And then you get to the non-statutory exemption, and it's essentially a three-part test. Again, easy to say, not terribly easy to interpret on occasion, although I think there are plenty of cases around in circumstances where there's no question about it that the non-statutory exemption applies. One is intimately related to the mandatory subject of collective bargaining, such as wages, hours, terms of working conditions. It does not have the potential to restrain trade outside the elimination of competition in wages and working conditions. And then finally, generally arises out of the collective bargaining setting. And kind of the landmark case here, the key case, is known as the Constantine case in the Supreme Court, which essentially said if a union, a plumber's union, is going to a general contractor and trying to get that general contractor to agree that that general contractor will not use a non-unionized plumbing subcontractor, then that is not covered by the exemption. On the employer side, there are other examples of where the exemption simply will not apply. Interesting one from the Ninth Circuit any number of years ago involving a grocer's union action, where the court ruled that a group of groceries or grocers could not come together and make an agreement that that if one of the grocers was the subject of a strike, that the other grocers would all come together and basically have a revenue sharing agreement. Gee, that sounds pretty obvious that you couldn't do that, but you'd be surprised people have that cases obviously that happen. There are all sorts of other agreements that I won't go into. Time is pretty limited, but there are just any number of cases like that, and the question is always, where do you draw that line between something that is affecting the labor market and something that is affecting essentially the commercial market? So that's good. Thanks, Bill.
Thanks, Steve. So it does sound like there's a lot of mischief out there still,
There is.
notwithstanding these clear limits. But so why don't we go to Jeff? And speaking of mischief, I'm only kidding. The labor exemption has attracted a lot of attention in the sports context. On some cases I'm sure you've been involved in. Could you walk us through how courts have recently applied the exemption in this area?
Yes. So in sports, it's been really remarkable because it's mostly been about the non-statutory exemption. There's very few sports cases actually involving the statutory labor exemption about the union, but there are quite a bit. Okay, sorry. There are quite a number of cases involving the non-statutory exemption. And most of the cases have been the employers in a multi-employer bargaining unit, basically the teams in the league, invoking the exemption against the union. So if you go back through the history, as we heard, of where the labor exemption came from, we used to like to say that like Samuel Gompers would be turning in his grave, because it became a weapon for employers to say, even though what we want to impose, let's say the labor law, so at impasse, you can impose your last best offer in bargaining, or you can continue the status quo of a prior restriction. That could be imposed by the employers, and they would assert the non-statutory labor exemption, saying it protects the collective bargaining process, and therefore we are protected. This was battled out by various sports unions against the teams and the employers in a whole series of cases as to when you'd have coverage and when you wouldn't have coverage in the 1970s through the 1980s. And it came to culmination in a Supreme Court case called Brown versus Pro Football. And in Brown versus Pro Football, the Supreme Court, much to my personal chagrin, because I did not agree with the result, ruled that as long as there is a labor relationship between the group of multi-employer bargainers and the union, even if the collective bargaining agreement expired, even if you got to a point of impasse in the bargaining, then the non-statutory exemption would continue. What did this lead to? It led to the plethora of strikes and lockouts that you've seen in professional sports since Brown versus Pro Football. Because the consequence of this is that the only choice for the sports player unions to be able to assert antitrust rights against their employer unions essentially has been to end their union. They disclaim it, which you could do under labor law. You could actually get a majority of workers to say, I disclaim you as a union. If you're a certified union, sometimes it's a decertification election. But so you have this perverse situation where workers are fighting to get rid of their union, and you have the employers, and this should tell you something as lawyers, the employers saying, no, you've got to stay a union. We want you to be unionized because we need our non-statutory labor exemption. I remember very well, Matt, when the first time the NFLPA, which was a member of the AFL-CIO, had to go explain to the AFL-CIO why it was good for the workers for them to stop being a union. This was back in 1989, and you can imagine that the general counsel of the AFL-CIO spent a few minutes thinking about that, but eventually came to the conclusion, and the AFL-CIO supported us. Think of it like we became like right-to-work advocates, that the union members didn't want to be in a union so that they can invoke the antitrust laws against the employer restraints. Most recently, that has played out in the context of lockouts, because the preferred strategy by employers in these leagues in recent years has been not to impose their last best offer or continue the status quo, but to conduct a lockout of the workers. And we had the last major case on this was the Brady litigation, which was in 2011 in the District Court of Minnesota. And the first argument there was, so the union disclaimed just before the end of the collective bargaining agreement and filed an antitrust case before Judge Nelson. It ended up in the District Court of Minnesota, seeking a preliminary injunction against the lockout because absent a non-statutory labor exemption, a lockout would be a group boycott of all the employers, probably a per se illegal group boycott against the workers in that context, absent an exemption. So a preliminary injunction was sought, and the fight by the NFL was, well, no, you really can't stop being a union. And they went to the NLRB and they said, don't let them stop being a union. They're refusing to bargain with us in good faith. The NLRB ended up never deciding that. They argued to the court should stay its ruling until the NLRB acted. The court rejected that. And then the court found the exemption had ended with disclaimer because there was no longer any purpose for the exemption once there was no longer a collective bargaining relationship, and enjoin the lockout. Then enter the Norris-LaGuardia Act. On appeal, the big issue was not the non-statutory labor exemption. It was the Norris-LaGuardia Act. Now, the Norris-LaGuardia Act was another pro-labor union statute that was passed to essentially prevent state courts, mostly with the culprits, but federal courts as well, from enjoining strikes. That was really what the Norris-LaGuardia Act was intended to do. It doesn't say anything, by the way, about lockouts. However, it says it's been interpreted to also protect, again, sort of the idea that there's a non-statutory application of the Norris-LaGuardia Act to protect lockouts. So the issue was, well, if the labor exemption to the antitrust laws ended, should the Norris-LaGuardia Act still protect the employer's lockout. And what the Eighth Circuit decided in a 2-1 decision is they said yes and no. They said that it protects employer lockouts for workers who are under contract, but it may not protect employer lockouts for free agents or new players who were coming into the league as rookies, but it reversed the injunction that was in effect at that time. Now, sort of one interesting question about all this, because it's sort of like it makes you sort of your head explode in terms of what you would think should be liberal conservative issues on this. If you think about the Supreme Court, how would a textualist think about a non-statutory labor exemption, okay, that's used by employers against unions when you have a specific statute, Section 6 of the Clayton Act, that creates an exemption and no other text in any congressional law that creates a non-statutory labor exemption? I'm just asking.
Did you want me to answer that now or later?
Oh, you'll get your chance. We're going to circle back to sports because that was great. But I do want to give Matt a chance to jump in. And it's going to shift gears a little bit to actually where the last panel ended on the digital question. So how should we think about how the labor exemption has been applied or should apply in digital markets?
Right. Thanks, Bill. And actually, I hadn't planned on it, but it's a nice segue from, because you don't think of your average NFLPA member and your average Uber driver as having a lot in common, but in many ways, they both really depend on this intersection between, the labor exemption is, in a way, the intersection between antitrust law and labor law in terms of their rights. And I'm just going to frame the issue because I know we're going to get into it more. But if you take Uber and Lyft and the other app-based companies at their word, all of the people that they retain to do the work are independent contractors. You can guess where I stand on that question, but let's just take them at their word for a moment. The question then is whether if they organize a boycott, if they organize to bargain, do they violate, do they fall within the labor exemption, or are they violating the antitrust laws? And just as a first cut, it's not entirely clear from the case law what the answer is, because we know from Columbia River Packers about selling fish, and we know from the grease peddlers case about selling yellow grease, whatever that was back then, that the sale of commodities by small business people is the sort of thing that's outside of the labor exemption. So when you get together to set the price of grease, whether or not you do it through a union form or not, that's outside. But when you have people, as I think is generally true with many, if not most of these app-based companies, who are basically selling their labor and very little else, and have almost no capital investment in the work they do, and are in the common law agency sense very much controlled by the app or the coordinator or the company, however you want to characterize the control. That looks quite a bit different from Columbia River Packers or the grease peddlers. So is the question, just to frame the question, we can get more into it. The question is, to what extent is the labor exemption coextensive with what the NLRB says is an employee versus an independent contractor, perhaps what some other agency says, whether the Department of Labor says you're an employee or an independent contractor, whether a state Department of Labor or a state unemployment office says you're a employee or independent contractor, or is there something more fundamental about the purposes of the antitrust laws that maybe would not intend to get at people who are basically just selling their labor and have very little capital investment in their business? And the other sort of touchstone in this area, of course, is superior court trial lawyers, which was not a labor exemption case, but a case where you had defense attorneys here in the district, public defenders in the district who conducted a group boycott to get the rates raised for reimbursement for taking on public defense cases. The Supreme Court, of course, found that was unlawful under the antitrust laws, but it was not litigated as a labor exemption case. So is there something different about people who are perhaps fall right over the line into independent contractor status but really the services they're selling are unskilled services. They're driving their own personal vehicle, which they use to take their kids to school and all the other things as well, versus perhaps a professional who's an attorney or an accountant who gets together. So these are the questions. I don't think we have answers, and I know we're going to have a bit of a debate and discussion about that.
All right, thanks, Matt. So, yeah, I was going to go to you next, but please go on.
Sorry. Well, I was just going to say that I think one thing I just want to add to what Matt said is that Columbia River Packers Association and the Grease Peddlers case, neither of those involved sort of primary joint bargaining, with the immediate buyer of the commodity. And so I would submit that it was not really teed up until Superior Court Trial Lawyers Association, and then obviously that can be distinguished in certain ways. Also, I think that was wrongly decided. There was a dissent, but.
All right, good. Well, I'll stick with you, Sanjukta. And taking you from the legislative history of the Sherman Act all the way to the present day on these digital questions. So, we hear the talk of a new gig economy and how digital markets are really causing many to question whether the existing antitrust standards are still fit for the job. Others take the view that, we have the tools. It's just a question of how we apply them and how we apply them in an intelligent way. So maybe you have some of the answers to the questions that Matt posed. And I'll start with one of them. So should the antitrust labor exemption turn on the employee versus the independent contractor classification?
Yeah, so I think Matt started to talk about that. I mean, I think I would say it's settled that the labor exemption, as a matter of existing law, that it's broader than just employee status. But I think there's questions about how much broader, and I do think that the gig economy tees up that question in various ways. I would just add a couple of things. One is that the mandatory arbitration clauses that Uber includes in its contracts with drivers have frustrated, I think, the judicial resolution of the independent contractor versus employee issue. I also would just, this was started to be talked about on at the end of the last panel, the platform's own extensive coordination of the ride services market, I think, raises novel antitrust issues as to them. I think we should discuss that as well if we're discussing the coordination of the drivers. And I think this was mentioned in the last panel, but that the kind of market coordination that the platforms are engaging in also constitutes control over drivers in a way that militates toward, I think, the employee status of the drivers. But I think just really briefly to map it, because we're not going to decide it all right now, I think that the labor exemption is clearly broader than just employee status. I think we don't know exactly how much broader. I do think that the early cases like Columbia River Packers Association, the Grease Peddlers definitely involved secondary action. So in that period, we really didn't have any cases saying that just straight up collective bargaining is a violation of the Sherman Act absent any type of exemption. In fact, I think that most people would have assumed that that is not the case. And even, for example, Thurman Arnold, who prosecuted, did not want a broad labor exemption at the time, I think took a more pragmatic attitude toward coordination among labor unions and sought to prosecute it where it was economically or socially harmful in some specific way, not in this sort of generic manner that it's a distortion of markets for workers to engage in coordination. So, I mean, I really think we need to get away from that concept. I think that's a very, very new concept, actually, relatively new in antitrust law. If I may add one thing, I think that the interesting thing about the platforms is that they tee up that question in a new way because they stretch the boundaries of what a firm is. We assume that firms in antitrust law are able to engage in joint, in price setting internally, right? If you go back to what I was saying originally about the legislative intent, the original trusts at which the law was aimed were functionally large corporations. They were not, they weren't sort of cartels, right? So what I call in my work the firm exemption to antitrust law, which we should be talking about if we're talking about the labor exemption to antitrust law, is, first of all, we should be on the table when we're discussing the labor exemption. The Wagner Act in its text talks about this and says that one of the purposes of labor law and of the labor exemption is to create true freedom of association for workers to parallel the freedom of association that capital already enjoys through the firm. I think that this has to be part of our conversation, because in the form of a firm itself, you already have association. It's not one person. It's not, right? There's already economic coordination happening. Bringing this back to Uber, I think that Uber and the other labor platforms really are useful in a way, insofar as they stretch sort of our conception of what a firm can do and what its boundaries are. They sort of claim something like single entity status, or at least they want the benefit, whether it's a joint venture or it's something, they want, essentially the benefits of entity status for antitrust purposes, and they want to disclaim that status for labor law purposes. So they want the benefits and not the responsibilities or the risks, right? It's not just labor law either. But we could, without even getting into that normative question, though, we can see how it is different from prior sorts of firms that were firms that owned plants, that were supposed to have efficiencies, that reduce costs in some way. We just assume that those efficiencies, first of all, productive efficiencies, can be imputed to the services economy. I think that's not obvious at all. Right? And that is, at a deep level, what leads us as a default matter to condemn coordination among Uber drivers, but to sort of have a mindset. I don't think that this is all, that it's sort of blatant hypocrisy. I think we sort of are trained to think this way. But to see Uber as a firm that is entitled to deference, even when now it is technically going beyond what conventionally were the boundaries of what I would call the firm exemption to antitrust law, because it is coordinating the prices of services that it is telling us that it doesn't sell, and that are sold by supposedly independent business people, right? And they're engaging in lots of coordination of that market beyond just the prices as well. So without even, I obviously have my views on this, but even apart from my views or what we might disagree upon, I think we should be able to agree that this unsettles some of the deeper assumptions of antitrust law. And I just want to get this in there, that we're talking about the labor exemption on this panel. The fact is, there are unstated exemptions to antitrust law that are written in. If we go back to first principles, property is actually an exemption, right? Federal antitrust law defers to state property law all the time, which is interesting, actually, because of federal supremacy. And it was internalized into federal antitrust law fairly early, as I said, in that trio of early cases. Knight, Northern Securities was an outlier, and then Standard Oil. But the reason why there are always exemptions is not necessarily a bad thing, is because economic coordination is inevitable. There is no such thing as pure competition. The firm itself is a limit upon competition. So let us have an honest debate about what types of limits on competition we are willing to cognize or accept or not, as a matter of first principles. And why exactly is it that an Uber Drivers Association is a distortion of market outcomes, whereas Uber's price coordination is efficient? We really need to approach this with fresh eyes.
So I assume everyone on the panel agrees with all of that. Would anyone like to chime in, or should we? All right, well,
I will for the.
Okay.
Expressing only my own views, to be clear, but I think it goes back to a premise that's baked into that whole calculus, which is that Uber controls prices. And because the other way to look at it is that Uber is a technology platform that really makes markets, in almost like an auction, where you have drivers who can choose to accept a ride or not accept a ride, who can be on the Uber platform, the Lyft platform, or neither, who are incentivized by Uber's algorithms during rush hour to still work by getting paid more for the same ride. And on the other side of that platform are probably almost all, if not all of us, who go downstairs, open our Uber or Lyft app, take a look at what it's going to cost me to go home now, and decide I either I accept that, or you know what, I'll take the Metro today. So the notion of control is so important, I think, to the construct, and I think it's a premise that we have to question. Because if Uber is not a firm in the sense of controlling price, but is really a market maker, then it's not the analog for labor law purposes. It's not the management side of a group of drivers who are independent, again, who are not signed by a contract to have to do anything with this particular employer. So an association of those drivers collectively agreeing to not participate on the Uber platform, and I'm making this up for, without X or Y term, doesn't necessarily flow to Uber on the other side is the bargaining. Now, it could be, and there could be, as you said, an argument for an exemption on the drivers. I haven't thought through that hard enough, and I agree with you that the non-statutory labor exemption extends more broadly than just to people who are currently in a union. But I do think the control point matters.
So can I very, very briefly respond to that? So I think the main thing that I would say on this control point, though, is that I think this misses the point, to be honest, because if we don't say about cartels that there's a lack of that the cartel is mandatory, that they've got gangsters out there enforcing, that is not a requirement of Section 1 liability, right? Entirely voluntary agreements to set prices are illegal under Section 1 as it's currently interpreted. So I don't think we should be setting this. I don't know why we set this higher standard where we say that Uber has to be actually controlling them, and that the question is whether Uber drivers can have the freedom to decline and not participate in this market. The point is that there is still effectively this, if for a moment, an analog to a cartel, but that's controlled from the top down by Uber, right? And I think that the only way, I haven't frankly thought through this sufficiently, and I think your rejoinder is interesting, and I'll think about it more. The way to make sense of your comment, to me, is that this is like Chicago Board of Trade, and that Uber is like the New York Stock Exchange or like the Chicago Board of Trade or something, and it's a market maker in that sense. I don't think that's a viable argument in the end, but I think that's the direction you have to go to make it work. I don't think that on the cartel point that there is this difference that can that the control point, I think, is not the way to distinguish the two forms of coordination.
So I want to bring in our labor expert, and I think one thing's clear is that so much turns on this employee versus independent contractor distinction. So, John, so leaving antitrust aside, how does labor law treat this distinction between an independent contractor on one hand versus an employee on the other? And then for gig economy workers, as we're talking about, does this binary distinction really make sense? Is it the best policy? Is there any middle ground that might afford workers some rights that traditionally independent contractors do not enjoy?
Thanks, Bill. And I promise I'll bring it back to antitrust at the end. In both labor law and employment law, this employee-contractor distinction is pretty foundational. Employees have all those rights that I walked through earlier: overtime entitlement, safety protections, organizing rights, the works. Independent contractors do not, being generally treated as independent business owners capable of taking care of themselves. And so, unfortunately, while the stakes are high when it comes to which side of the line a worker falls on, that line isn't necessarily the clearest. So under the Fair Labor Standards Act, for example, we tend to look at the degree to which workers are economically dependent on a business. Economic dependence is a pretty thorny concept, meaning that sometimes you have business models spring up, like some of the ones we're discussing today, where those models don't fall cleanly on one side or the other. And again, the stakes are high. To your second question, Bill, I think that a binary distinction for gig workers means either no protections while they get to keep working under the current business model, or a whole host of rights and entitlements at the risk that the business model changes radically or just disappears. So if I'm a company whose smartphone platform connects handymen with projects, and I'm suddenly the employer of all those handymen, as maybe it's just happening now in California, the full suite of federal workplace safety rules now applies to me. This despite the fact that I may know very little about these handymen individually, and the fact that I provide no on-site supervision to their work whatsoever. So maybe I'm forced to furnish live supervisors, if not one-to-one, maybe on some kind of random rotating basis. Maybe I can absorb that cost, maybe I can't. And if I can't, then I shut down, and a whole lot of handymen are now going to miss out on the work opportunities I was connecting them with. So given the sharp binary here, yeah, I do think that the question of an appropriate middle ground is something worth exploring. There are legislative proposals for some sort of intermediate independent worker status that would confer some, but not all, of the rights and benefits that typically come with employee status. The challenge there, I think, is really drawing the right line. And I don't know whether anything close to a societal consensus has emerged about how to draw it. So while it has some precursors, the gig economy that we're talking about has really only started to take its current shape in the last decade. Contrast that with the employee-contractor distinction, which mostly only started carrying federal workplace rights and obligations as of the New Deal, after Anglo-American law had had a century to really digest and unpack the meaning of the Industrial Revolution. So instead, bringing it full circle, I'd like to suggest that an expanded antitrust exemption is something that's worth exploring further. Instead of getting into the substance of which workers ought to have what rights at what cost, an expanded exemption would presumably remove a cloud on a process, namely some kind of collective action outside the NLRA, that those workers could use to at least attempt to negotiate terms and conditions of work that may make sense in the context of a particular service, like ride sharing, without killing the whole model. There's a lot to think through there, so I'm glad we're having this conversation.
So thanks. So I promised in our time we would get back to sports, and I want to start with I think the question we left off with Jeff, and I think I'll put it to Derek because I think you had a reaction. So is the non-statutory labor exemption just simply a tool for employers to go after the players and hurt them in this context? What do you think?
No. But I'll expand. So to provide context to my answer, which is no, go back to the beginning of the relationship. The NFL Players Association, the players decided to get together to enter into a collective bargaining relationship with the employers. Collection of employers, the teams in a given league. As part of that, they went and they demanded collective terms, league-wide terms that would apply to all the teams. So this is the classic collective bargaining process at work that John talked about. And we know from labor law, section 8B3, that a union may withdraw from collective bargaining with a multi-employer bargaining unit only before bargaining on a new contract has begun. If you all think about the airport, there's a big sign above the TSA screening that says, once you start this process, you can't turn around and go back. And there's lots of good reasons for that. And labor law has lots of good reasons for saying, we want these parties to bargain. We're going to make them bargain. We're going to make them bargain in good faith, which means once you take on the protections and the weapons of the collective bargaining process, which for Jeff's clients involve strikes and collective demands, you can't just suddenly turn it off and say, you know what, that's not working very well. I didn't like the counteroffer. We're done. So what Jeff refers to as the weapon of the non-statutory labor exemption actually presupposes the weapon of the antitrust laws. What the Supreme Court said in Brown, and I'll read it because it's pretty apt. Congress, through these exemptions, hoped to prevent judicial use of antitrust law to resolve labor disputes. It's that simple. So this whole decertification effort is an effort to weaponize antitrust law in the middle of a collective bargaining process. Now, I say in the middle of, Jeff and I can disagree of when that collective bargaining process ends. The Supreme Court agreed with us on that it survives past impasse. Jeff and I would both agree that no one has decided how much longer past. And we can come back to that if Bill wants us to later. But the basic point is the weaponization here is not of the statute, of the statutory exemption. It's of antitrust law to begin with.
An alternative way to look at that is that it's the weaponization of labor law by employers to prevent competition in one of the few instances where workers have sufficient bargaining power to make it work for them.
So Derek's history doesn't go back far enough, and it doesn't go up to the present enough either. So
we're going
starting way back.
Madison v. Marbury.
Starting way back in sports, the teams got together and imposed joint terms before there was any labor union in any professional sport. So it was not a question of players first getting together and forming labor saying, we want you all to bargain together. It was a response to the fact that the competing employers set terms and conditions of employment collectively, which, by the way, was an antitrust violation before any of these unions were formed. So that's the actual history of how it came about. But going forward, what Brown makes absolutely clear is that the labor exemption does have an endpoint. Okay, it says that unequivocally. You're right, it doesn't identify exactly when that is, except it says it probably, well, it says two things. One, I believe it says that if you decertify, disclaim, that's the end point because the relationship ends. It suggests even that if you had an impasse that was so long that bargaining became meaningless, you might even end the exemption even before that. But wherever that point is, it's there somewhere. And this flows from another part of the NLRA, which is Section 7, that says that just like workers have a right to collectively bargain, they have a right not to collectively bargain. And so what happens in these cases is that they decide that bargaining is actually not in our interests for whatever reason. Okay, and I gave you all the reasons why in sports unions have concluded that for one reason is striking is extraordinarily difficult when your average career is 3 years long and the employer's average lifetime is multi-generational passing on of the team. So it sort of distorts the ability to use strike as a meaningful weapon against employers. And if you can't strike, but they can lock out, then labor law doesn't seem like such a good remedy for you, while antitrust law would be a great permanent remedy for the workers. And what's inevitably happened is when unions have disclaimed in sports, again, a total reversal in any other employment context, it's the employers who insist the unions get reformed as a condition of settling with the workers. So, but going back to the original disclaimer back in 1989 through 1992, when the antitrust action was settled, which was the Reggie White case, there's a provision in that antitrust class action that says if the union's not reformed, I think it was in 60 days or 30 days, whatever it was a provision put in at the request of the NFL teams, then the NFL had the right to void the class action settlement and go back to litigating. So they were demanding that the union be reformed, and the union was reformed because they liked the settlement and they didn't want to give it up, and it's there. But again, to me, this is sort of like a perversion of whatever the labor exemption meant, whatever the non-statutory labor exemption meant. It wasn't supposed to be, and I agree with my colleague here exactly. It's a weaponization by employers of the antitrust non-statutory labor exemption to use against labor in that context. And just to give you one other twist on this to tie sports to the gig economy and independent contractors, there are athletes who fit into this kind of amorphous bucket as well, like tennis players, for example. And so what tennis players have done historically, because they're treated as independent contractors, so they couldn't formally unionize at all, is that we've ended up in these situations in both men's and women's tennis where the players broke away because they couldn't collectively bargain or strike in some way that they thought was possible to form their own competing leagues. And that's how so in effect, they went from labor to management or to capital, and in effect sort of carried it to its logical conclusion. That didn't work all that well, and what then happened in both men's and women's tennis was eventual legal battles and settlements where today both the ATP, the men's tour, and the WTA, the women's tour, has players and tournament owners, which would really be the management and labor, have equal votes. And they developed this bizarre system where they have a neutrally hired president who is the tiebreaker in the vote. And I think both labor and management would agree it's become a very unsatisfactory system. In other words, the tournaments don't like it and the players don't like it. In other words, they would be more comfortable in a traditional labor management relationship, but this whole amorphous statute of they're not employees, they compete in tournaments, prevented that from coming in. So I don't know what's going to happen in either of those organizations. I just can tell you you have a situation where neither side likes the current arrangements in terms of that.
So I want to shift gears a little bit, and I know we're low on time, but there's a few of you who haven't had a chance for a little while to weigh in. So I'll start with Matt. A lot of the discussion is sort of focused on, I guess, what we might say call non-traditional arrangements between employers and employees, the gig economy, sports, for example. I have a question about how the labor exemption might apply to public sector unions, which is in some ways a slightly less traditional model than the for-profit corporation and then employee relationship, and specifically how the non-statutory labor exemption applies. So, for example, in the First Amendment context, last year, the Supreme Court held that the agency shop provision of a collective bargaining agreement that required non-union members to pay union dues violated those non-members' First Amendment rights. The court emphasized, in that case, the differences between public and private sector bargaining. In the private sector, unions negotiate with for-profit companies, whereas public sector unions negotiate against the government, which is ultimately funded by the taxpayer. In that case, that made that the public sector bargaining activity a matter of public concern. So I guess my question is whether these differences between public and private sector unions could spill over into how courts or the Supreme Court might consider the labor exemption, whether the statutory or the non-statutory labor exemption.
I mean, I don't actually think so. I know the issue's been raised here and there, but hasn't really gained any traction. And because, I mean, again, I think that if you look back into the broad terms used in the Clayton Act and in the Norris-LaGuardia Act, I mean, the thrust of it is the broad right of employees to get together to negotiate their terms. And in effect, if it's a charter school that's a private school providing a public service, there's no question that's squarely within the labor exemption. And if you cross the street to the public school and engage in the same collective bargaining, the same activities at play. So I don't see a particular issue there. And in addition, the fact that you have the state on the other side, and all of the collective bargaining in states that permit such collective bargaining have passed very detailed statutory and regulatory regimes for that collective bargaining, show a very clear purpose of the sort that's broadly analogous to the state action exemption that would permit that sort of bargaining, outside of the realm of the antitrust laws. So I haven't seen it become an issue in any litigation, and I don't really see it becoming an issue.
So we're almost out of time. Steve, we had a series of questions about the Writers Guild case that you and Jeff are both involved in. And I'm not sure we have enough time to get into the details of that case, but what I will ask is, in some ways the case does raise the question of what are the limits on what employers can do when bargaining with a union that's protected by labor law? Do they depend on the bargaining power of the counterparty?
Yeah. Well, let me say first that the case is obviously, thanks, Jeffrey. It's several months old, but now it is brand new again. The judge has consolidated the 3 agency cases against the Guild, which is our client. We represent the Guild in this matter. Going to get a new complaint from Jeff and his co-agencies pretty shortly. So it's a little bit in the early stage. But yeah, that is a issue in the case. And I must say, I think that from the Guild standpoint, this really is not a cutting edge case. From what the Guild has done is wrapped in decades of precedent from the Supreme Court and other cases in terms of their ability to control the franchising of the agents that will then represent some of the Guild members. So I don't think that's really an issue. I think Jeff and I probably disagree with that. But look, you got a minute or so if you want.
Yeah, there's no time to really do it. I just say it's an interesting case because the parties don't really disagree that unions have the right to franchise, if you want to call it, or certify agents in these industries where they do that. That's not the subject of the disagreement. The subject of the disagreement has to do with, as you said, sort of the limits of this. So one of our issues in this case will be adjudicated is that in this case, the Writers Guild combined, for example, with managers and lawyers to engage in a coordinated, in our view, concerted action against the agents, and the managers and lawyers are non-labor parties. And that takes it, at least in our view, out of the statutory exemption, and in terms of the conduct, it then becomes whether or not it's a proper invocation of the non-statutory exemption. When we're not even talking now employers versus labor in terms of this, we're talking about the use of other actors in our view, going after commercial activity. But there isn't time really to debate that now or discuss it. I think it poses extremely interesting questions about where the exemption would end or not end in this type of a case.
That would take us through dinner, I think, at least. So.
At least.
Well, the court will have plenty of time, and certainly both sides are well represented. We are out of time, and I just want to thank all the panelists for coming out. This has really been enjoyable. I wish we could go on forever, but time is what it is. Thank you.
Always a pleasure. Take care.